Good morning.
Good morning.
Good morning. We're live.
Okay, I'll go ahead and call to order this hearing of April 9th, 2025 for Z0477-25 proposed event facility. My name is Joe Turner. I'm the county's hearings officer. I'll start with some brief announcements and a summary of the process that will follow so everyone understands how you can participate in the hearing today. I start by saying I'm not a county employee. I am licensed as an attorney, trained as a planner. I say that so you know you're getting an independent review of the application before me today. Um, my role as the hearings officer is to conduct public hearings and make decisions about certain land use matters in Clackamas County. In making those decisions, I'm required to apply the county's existing laws. I am not a policymaker. I don't have the authority to vary from or change the laws. If you think that the laws need to be changed, you can work with Planning Commission and Board of Commissioners to do that. But state law requires that this application be judged based on the laws in effect when the application was filed. As a hearings officer, I'm to provide an unbiased decision maker. I believe I am unbiased with regard to this application. I have not had any pre-hearing contact with any of the parties regarding the substance of the application, and I don't have any interest in the subject property or any of the surrounding properties. But anyone has the right to challenge my impartiality, to argue that I'm biased in one way or another, and you can do that when it's your opportunity to testify. Procedure will follow. I'll start by asking staff to summarize their staff report, copies of which are available on the county's website. Then the applicant will have the opportunity to present their proposal and respond to the staff report. Then if anybody else wants to say anything in support of the application, they may do so. And then anyone who wants to testify in opposition or with questions or concerns. That should cover everybody who wants to say something about this application. You fall into one of those categories. Once everyone has had an initial opportunity to testify, I will give staff and the applicant alone the opportunity to respond to the testimony that was offered. If those responses include any new evidence, I will give everyone a chance to respond to the new evidence. Otherwise, I'll close the public portion of the hearing without taking any further public testimony and announce what I'm going to do. Um, in most in most cases, I will issue a written decision within about 2 weeks after the close of the public record. I'll send my decision to the county, and the county will send it to parties of record. So anybody who testifies orally or in writing before the close of the record will be sure and receive a copy of my decision when it's issued. If you decide you don't need to testify but want to get a copy of my decision, you can contact staff and they'll put you on the mailing list as well. Um, Anyone with an interest in this application may offer relevant oral or written testimony, but please only speak when I identify you for that purpose. There's no arbitrary limit to the length of time you can testify, but your testimony should be relevant to the applicable approval criteria which are set out in the staff report. Um, It is important that you make your best case to all parties make their best case to me. My decisions are final for purposes of the county, but may be appealed to the Land Use Board of Appeals or LUBA. However, LUBA generally does not allow new testimony and evidence on appeal. They'll decide any appeal based on the record before me. So if you feel it's important that myself or any future decision maker knows something about this application, you need to make sure it gets into the record before me in order to raise an issue on appeal, or excuse me, in order to preserve your right to appeal, you or someone expressly representing you must testify orally or in writing before the close of the record. And in order to raise an issue on appeal, someone must have raised that issue before me with enough specificity that everyone can understand where that issue is. Um, if you feel you need more, or if the applicant wants to object to any conditions of approval on constitutional grounds, they must raise those issues before me as well. If anyone feels they need more time to prepare, you can ask me to hold the record open or to continue the hearing. If I hold the record open, you'll have an opportunity to submit additional written testimony and evidence before I make a decision. If I continue the hearing, we can come back and do this again at a later date. But whether or not the hearing is continued or the record is held open for any other purpose, state law requires that I hold the record open for an additional week for the applicant alone to submit a final written argument without any new evidence. The applicant can waive that right if they choose, but if anybody else wants me to hold the record open for any other purpose, or if anyone wants me to continue the hearing, you must make that request before the close of the record today. Also, my decisions must comply with state law that requires that I issue a final written decision within 150 days after the application was filed, so there's some limit to how long I can continue the hearing or hold the record open. When you testify, please begin by stating your name and your full mailing address. Please spell your last name so I get it right. And if you represent someone else, please say so. I think I said this, but there's no arbitrary limit to the length of time you can testify, but your testimony should be relevant to the applicable approval criteria, which are set out in the staff report. Also, please don't repeat testimony offered by yourself or earlier witnesses. Repeating your testimony doesn't make your case any stronger. The only issue before me is whether the application does or does not comply with the applicable approval criteria. But that concludes my introduction. Staff will give us an overview of the Zoom process, or whatever format yeah, Zoom, and how you can indicate when you'd like to testify, and also give us start with a summary of the staff report. Ms. Fields.
Okay. Today's hearing is being recorded as required by law. The county will make every effort to post the recording on the county website later today. Panelists for today's hearing, which include the hearings officer, county staff, the applicant, and the applicant's representatives, have both audio and video capability. Audience members' camera will not be turned on at any time. Audience members' microphones will be muted unless they wish to testify, in which case they will be called upon to do so by the county staff moderator. There is a designated time during the hearing when it will be open for testimony. The hearings officer will make it clear when this is. If you want to provide testimony, you will use the raise hand button. For people who have called in or joined by phone, you can press *9 to raise your hand. Staff will call upon you when it is time to provide testimony. You will unmute your microphone and then provide your name and mailing address when you begin. Once you have provided your testimony, you can lower your hand and your microphone will be muted again. If the record is left open at the end of this hearing and you wish to submit additional written testimony, you can email that testimony to myself, Joy Fields, at jfields@clackamas.us, or mail it to the Clackamas County Planning and Zoning Program at 150 Beaver Creek Road, Oregon City, Oregon 97045. My email address is also available on the webpage where you found the Zoom link for today's hearing. Testimony must be received by 4 p.m. on the day the record closes. People who wish to testify and provide their mailing address will receive written notice of the hearings officer's decision and a link to access the full written decision. If you do not wish to testify but would like to receive the decision, you must provide your email or standard mailing address by emailing me at jfields@clackamas.us. These instructions will be reiterated in my staff report, which I will begin because the hearings officer indicated that that was the next thing. We are here today for hearing Z0477-25. It is a conditional use for a home occupation to host events. The applicant is Barclay, and the case file number is Z0477-25. As noted in testimony received by the applicant late last night, I was not the original planner assigned to this file. So in the notice of today's hearing, Nick Bateman was the planner assigned. So I took over this application later in the process. As noted, this is a public hearing using the Zoom platform, and the hearing is being recorded. It will be up on the county's website where the link for today's hearing was located when we are able to upload it. The audience members' cameras will never be turned on, and there is an opportunity to provide public testimony. This opportunity will be made clear by the staff moderator, and you will raise your hand to provide the testimony. If you're on the phone, *9 is the best way to raise your hand. When you begin, please state your name and mailing address. That ensures that we know where to send the hearings officer's decision. And when you are finished, please lower your hand. My email is jfields@clackamas.us, and the address of the office is on the screen. So the subject property where the conditional use is being proposed is on 2 tax lots. They are combined as one legal lot of record. There was a property line adjustment in 2004 that combined them, and it's just under 80 acres in size. The property zone is exclusive farm use, and it's at 12112 South New Era Road. The applicant is proposing to host events, and we have received, at the time of the staff report, we have received one comment, which was generally concerned with the character of the building, traffic, and consistency with the EFU zoning. Staff recommended denial because of the changes to the Oregon administrative rules, concern about noise, and other items that I will touch on later on. I think there may be a typo in this timeline, Joe. And so I want to make sure that I tell you the correct timeline later.
Okay.
My recollection is that this application was deemed complete on the 4th of February. If my recollection is wrong and the text here is correct, then this timeline is correct, but I will have the correct dates for you at the end. So I apologize.
That's okay. Thank you for noting that.
The application is for a new venue. The site plan identifies the new venue up near the tree line, near the center of the property, at the end of the driveway, just south of the vineyards. I included the aerial image with the topography because the slope of the property slopes down from where the proposed venue is located to the residence located further south. As a conditional use, the application is subject to 1203. The home occupation to host events is identified as a conditional use in the underlying zone. The underlying zone, as I mentioned, is exclusive farm use. The conditional use criteria require that the site is suitable based on the size and the natural features on the site. The site, it would be suitable. Staff have concern about noise, and the topography did not help to capture the noise created by the events. And so with sufficient conditions of approval regarding outside noise or additional information from the applicant, the site is suitable as conditioned. The criteria requires that the conditional use complies with 1007-07 and that the transportation system is safe. 1007-07 is concurrency, and home occupations are explicitly exempt from the concurrency requirements in 10707. We did receive comments from the Transportation and Engineering Program regarding safety, and with sufficient on-site circulation and parking for vehicles, there is likely no conflict on the transportation system from the proposed events at the driveway entrance. And with a permit from the Transportation and Engineering Program to ensure that all the roadway driveway entrance standards and circulation standards comply with 1015, the safety of the transportation system would be adequate. 1203 requires that the applicant provide evidence that the comprehensive plan goals and policies were met. The applicant identified that winery and home occupations are uses allowed in the EFU zone. They did not identify specific comprehensive plan goals or policies that were met. Staff included in the staff report the comprehensive plan goals and policies that apply to agricultural land. And because the applicant did not provide evidence about complying with the goals and policies, staff used the Oregon Administrative Rules to guide whether or not the proposed land use would conflict with agricultural uses. And because the revised Oregon Administrative Rules that became effective in Clackamas County January 1st, 2025 was not met, staff found that the goals and policies of the comprehensive plan were not met. The Section 1203 requires that any environmental overlays that are in the 700s are complied with, that any standards for special uses in the 800s are complied with, and that the applicable 1000s are complied with. The applicable 1000s are discussed further below. There was no environmental overlays that pertain to this property, although the statewide wetland inventory did indicate that in the area of the forest just south of the proposed development, where the topography is steeper, there is a waterway that is on the statewide wetlands inventory. It is not subject to Section 704 of our zoning code. It was not on the adopted inventory. The last criteria in 1203 was that the use does not substantially limit, impair, or preclude the uses of surrounding properties for the primary uses. The surrounding properties are predominantly agriculture or rural residential in use. As the EFU zone, agriculture is farm and forest uses are the predominant use in that zone. The properties directly to the west are in equine use. They have horses. And the applicant provided a farm and forest impacts test that addressed the impacts to grass seed production, livestock, and grazing. As I mentioned, there are several sections of the 1000s that apply to home occupations to host events. They include outdoor lighting. At the time of the staff report, the applicant had a note on one of the plans that outdoor lighting was met, but the extent of the lighting was not clear. And staff found that there was no lighting plans or specifications on the extent of the lighting. And because the proposed use is proposed at a higher elevation, there was concern for lighting. The applicant submitted additional evidence last night around 9 p.m., and staff has not had an opportunity to review the narrative in detail. However, lighting specifications were provided in that. And so the findings for outdoor lighting will be impacted by Exhibit 11. The lighting specifications start on page 45. 1006 are the utility specifications. They are not specifically addressed in the home occupation to host events criteria, but they are addressed in the conditional use submittal requirements. And they require that preliminary statements of feasibility are received to ensure that the surface water management, water usage, and utilities are sufficiently addressed in conditional use applications. The applicant in Exhibit 11 updated the preliminary statement of feasibility. And so the criteria for 1203 submittal requirements are now met. As I discussed earlier, roads and connectivity do have to be addressed by home occupations to ensure that the transportation system is adequate for the proposed use. They did provide a traffic analysis, and at the beginning of the meeting, the applicant indicated that their traffic engineer is here with us today. Staff found that the traffic study showed that the transportation system was adequate for the proposed use, but did not indicate that the proposed use was incidental or subordinate to residential use based on traffic. Signs are another criteria that home occupations to host events have to meet. There is a sign limit or a size limit to signs in natural resource zones. The sign design that was provided in the application is too large for meeting the criteria in 1010. However, if the sign size is reduced to meet the limit, it could comply, and so as conditioned, the sign requirements could comply. Additionally, parking and loading are really managed by the Transportation and Engineering Program to ensure that the surface of the parking area is adequate, that the parking spaces are delineated, that the parking spaces meet the size requirement, and that there's adequate circulation on site for the home occupation. As conditioned, with coordination with the Transportation and Engineering Program, this could be met. And as proposed, it looks like it would be met, but to ensure that the roadway standards are met, additional coordination is needed. The underlying zone is exclusive farm use. In that zone, our zoning code requires that there be a farm and forest impacts test. The applicant provided a really good farm and forest impacts test, identifying the surrounding uses and the potential for impacts from the proposed use. And the one thing that staff found was that they did not necessarily address the impact of litter. The Oregon administrative rules that were updated provided additional guidance on farm and forest impacts test for agricultural land, and litter was one of those impacts. As conditioned, coordinating with sustainability to ensure that the garbage area, it meets the criteria and that the litter is addressed, this could be met as conditioned. Setbacks were met, and the underlying zone specifically requires that a home occupation to host events or a conditional use is not used as justification for a zone change. The proposal does not include a proposal to change the underlying zone. So there was no concern from staff regarding that. That is just informational, that in the future, the use of the site for events cannot be used to justify a zone change. The specific criteria for home occupation to host events include that the operator lives on site. There is an existing manufactured home on the property that was placed there with the appropriate building permits. Evidence in the record indicates that the home is about 1,600 square feet. So there is a home on site for the operator to live in. The application indicated that the operator would be living there. The number of employees are limited to 5. The applicant indicated that they could meet that limit. In the home occupations to host events criteria, there is a requirement that the type of building is designed such that they are similar to buildings normally associated with uses permitted in the EFU zone. In the original submittal and subsequent submittals prior to the staff report, evidence was not provided that the proposed use was similar to surrounding agricultural buildings. The applicant did provide pictures of barns in the area in Exhibit 11. And the barns in the images provided in Exhibit 11 do not include covered porch areas. And thus, staff find that the proposed design still does not match what is normally, customarily allowed in the applicable zoning district. Tents were not proposed. The impacts on dwellings was not specifically addressed because, or was not sufficiently addressed because of the concern staff had about outside noise during the events. In the application, the hours of operation that the applicant identified was 9 a.m. to 4 p.m. That comes into play when we look at other criteria such as water usage and the intensity of the proposed use compared to the intensity of the residential use. And so 9 to 2 being the hours of operation is greater than 8 hours. In Exhibit 11, they identify water usage. And they include water usage for events of specific time periods. And so that is why I'm highlighting that here. But the hours of operation meet the criteria in the zoning code. In some places of the application, they indicated that there would be 2 events a week. In other areas, they indicated 3 events per week. So staff concluded that the proposal was for 2 or 3 events per week. That meets the criteria in 806. The code allows up to 300 guests at events that are conditional uses and tied to home occupations. The applicant proposed 200 guests, or up to 200 guests. As I mentioned previously, additional information on lighting was provided in Exhibit 11. So although at the time of my staff report, no plan was provided, you'll see in the site plan provided on the screen that the lights in the parking lot were identified on the site plan that was originally provided and considered by staff. And there was a note on the site plan about outdoor lighting. With the additional evidence that the lighting proposed would be shielded, the lighting criteria appears to be met. The site plan also identifies the location of the outside events. And so the building is proposed, and then the outdoor event area is proposed to the east of the building. The lawn area, ceremony area is identified on the grading plan. In Exhibit 11, the applicants identified that the outdoor noise was tested here. I didn't see evidence of that in the original submittal, and so I did not have any indication in the staff report that noise was considered on the actual property. Portable restrooms are not being proposed. They are proposing restrooms inside the event venue. As I mentioned, the proposed sign design is too large to meet the requirements of 1010, and Section 806 requires that signs comply with the sign requirements. The applicant indicated that the attic in the event venue has sufficient space for storage, and that would be used for the event equipment when the events were not taking place. So storage, the requirement appears to be met. And the applicant agreed that there would be no appearance of the home occupation outside of event times. The greatest concern staff had about this application was that the revised Oregon administrative rules that Clackamas County is subject to included requirements that the scale and intensity of the use is no more intensive than the limitations and conditions for uses otherwise specified in Oregon Administrative Rule 660, Division 33, 120. And that the use is accessory, incidental, and subordinate to the primary residential use of the dwelling on the property. Because the application narrative identified that the home occupations to host events may or may not be wine related, and that the home occupations were necessary to support farm use on the property, staff found that the item in Oregon Administrative Rule, Chapter 660, Division 33, 120, that is a typo, I apologize, for agritourism and other commercial events and activities applied. And because the proposal could also be considered commercial events or activities in support of agriculture, the limitations for agritourism and other commercial events apply to this home occupation. Looking at the Oregon revised statutes, the limitations for agritourism and other commercial events was not met by this application. And that is the primary reason staff recommended denial. Are there any questions?
Yeah. Before I forget, if we can clarify the 150-day clock before the end of the hearing, we don't need to do that right
Yes.
now. page 15 of your staff report. Oh, towards the bottom of the page, second to last paragraph says, no, the last third and second from the end of the page paragraphs talk about the driveway access. There are two driveways to this site. Staff recommended limiting access to this entrance since it appears to be constructed in accordance with applicable standards. I assume that was the northern one.
Yes,
Should
the northern
that just
one.
be event-related access restricted? Because the
Yes.
residence has. Okay, I would add that
Okay.
language then. I think that was.
The transportation and engineering staff noted a entrance permit for that northern entrance.
Uh,
And usually an entrance permit indicates that the driveway meets the requirements. I would want that confirmed for the increase in vehicle trips, but I have no reason to believe that the driveway constructed in accordance with the entrance permit would be problematic. So, yeah,
it
that's
is
why I suggested that it be the primary entrance for the event.
okay. I'll add the primary entrance for the events to condition 15.
Great.
Um, is there a access permit or whatever the term was for the existing driveway, the residential driveway as well? That an issue?
The staff from the transportation engineering did not indicate that.
Okay.
Um,
I think that would be more of an enforcement issue. I don't think it's really relevant to this application given that condition.
I would
Uh,
agree.
Page 19. Yeah, I think you may have somewhat addressed this. Oh, yeah. The OARs that you referenced and the specifically regarding agritourism, that are you saying that if it is because it is potentially agritourism, it would be limited to 18 events in a calendar year, which is OAR 660-33-120?
And Joe, when I originally said 18 events in the staff report, I was going under the assumption that there was additional land within the road right of way and that the area of the property was 80 acres because it is so close to 80 acres. Looking further before the staff report was finalized, it is under 80 acres. And so instead of 18 events per year, the Oregon revised statutes limit it to 6 because
Okay.
of the size.
Let me write that down real quick and then I have a follow-up question.
I thought I had found where I had said that, but in the findings for the Oregon administrative rules, I removed the section of the rules that apply to properties over 80 acres.
Okay. But if this were approved, would it be limited to 6 events per year?
If it follows the limitations for agritourism and other commercial events, yes.
Okay.
Or that's my reading of the Oregon administrative rules.
On page 33. Oh, the top of the page, 1, 2, 3, fourth sentence, just up here, or fourth line, the last sentence, it is unclear from the time frame when guests would be, and it kind of peters out. I'm not sure that was intended.
Arriving to the site.
Okay, thank you.
Having events start as early as 9 and end by 10. I'm not sure if the guests for the events would be arriving at 9 or if it would just be the employees that are setting up. So
Okay.
the hours of operation and the timing of the event was not clear in the submittal for staff.
And then further down in that same paragraph, it says 30% of those anticipated to be coming from South Central Point Road would generate about 23 intersections, excuse me, trips at an intersection that is forecasted to have issues in 2028. I didn't see, I may have just missed that, but what issues which intersection and what issues? Central
The
Point and what?
the traffic engineer is with us here today, or
Okay.
that's my understanding. Looking at the traffic impact study, they said that there was a potential concern for left turns at that intersection, but I was not sure from the traffic study whether it was left turns from South Central onto New Era Road or whether it was left turns from New Era Road onto South Central. I um and so I apologize for the lack of clarity in that statement. But there is a sentence in the traffic study that shows concern for uh, the peak hour left turns at that intersection.
Okay. Thank you. And I guess my last one was the code requires that the buildings be similar to agricultural buildings. It has more language than that, but in a summary, um, the restroom and break room, they're rather large. It's not is that it's my recollection that Luba has addressed that they have to be, if you're going to provide restrooms, they have to be similar, to what's existing in the area.
That is also my recollection. And changing rooms in restrooms are not similar, or having women and men break rooms. I would not find similar to restrooms in the EFU zone, but I did not have any evidence to that fact in the application to base that on. That is just based on what I have seen in the EFU zone in
Okay.
Clackamas County.
That was all the questions I had for staff. Thank you. It's the applicant's opportunity to testify. I know there are a number of representatives here. I assume Mr. Tyler's starting us out, though.
Yes,
Or
thank you,
Mr.
Mr.
Smith,
Turner.
rather.
Thank you, Mr. Turner. Can you hear me okay?
I can, thank you.
So I'll address all of those, but I want to
Can I get you to state your name just for the record so we know who you
Tyler
are?
Smith,
And
attorney
you're
for
the applicant's attorney?
Barclays, yes. So we
Okay.
have Mr. Barclay here. We have Joe Bessman, who's our traffic engineer, and we have Ken Diner, who's the architect. You will see, I want to point out, as Ms. Fields had mentioned, we did change staff people midstream. So unfortunately, I think that led to a fair bit of misunderstandings, miscommunications. For instance, like the sound study. She apparently didn't even see or know there was a sound study in there. And so we'll go through this. I'm going to go through in great detail and point out, because there is a lot of differences between what we have proposed and what this applicant is really about, and some of the conclusions in the staff report. You'll see we prepared a narrative last night. Obviously, we get a week from getting the staff report, and we saw the staff report had a number of either misunderstandings that we talked about with Mr. Bateman, or misunderstandings of what we had in the actual record. And so I want to go through those. And I would, ask Your Honor, in considering this, to make sure to review all of the exhibits. We have exhibits A through, I believe it's J now, or actually K. So we have quite a few exhibits on this that have been submitted over time. And I point that out because there's no denying that the Barclays would like to eventually have an actual winery there. But that is not what this application is for. There's grapes growing on the north end of the field. This application is not for a winery. A winery is a completely different application. A winery is is a type 2 hearing, different statutes, different administrative rules all apply to that. What was sort of lost in the whole conversation about agritourism is this is definitely not an agritourism of situation. The applicant that we are applying under Oregon Revised Statute 215.448, which is the specific and direct and explicit state law for home occupations to host events. Okay, that is drastically different than ORS 215-283, which was what was cited and sourced and discussed in the staff report. So there are some provisions of ORS 215-283 that apply, but not the ones that we're talking about agritourism, not the ones that are talking about 18 events, not the ones that are talking about 6 events. Those are for wineries. Those are for agritourism. That is not what this is. There is no winery there. Okay, what is there on site? And I'll also point out in the staff report, it was, yes, there was conversation about 2 events max per week is what it was. And there was conversation about no annual cap. But we've changed that. We've suggested and to minimize and to, as an additional mitigation, a maximum of 3 on any given week, maximum. So this isn't 2 to 3. I mean, a range like 2 to 3 would be, oh, we have to have 2. No, we're wanting a maximum of 3 per week and a maximum of 84 events in any given year. So that that's sort of the cap on it. And with the same thing with hours. There was a conversation just a couple of minutes ago about hours of operation. We aren't planning the events today, right? We want these are windows. So the maximums are there so that we can get a scope of what is the impact, how many times it'll be used, when it might be used, how many times a week it might be used. The same with hours of operation. The hours of operation doesn't mean that we're going to have anybody there besides the owner living in their house on a given day at 9 o'clock. But when there's an event, we might have somebody show up at 9 o'clock to bring in some chairs. I don't know, whatever it might be. And then the event might be at 7 o'clock at night, right? And the event's 7 o'clock to 10 o'clock or something like that. We don't know when that's going to be. So those are just generic measuring sticks of what the approved hours of operation might be so we know when we would be approved to be there or not be there. That's all those are. So again, here weddings, weddings are typically somewhere between 2 and 4 hours. So that's realistically what we're looking at as a practical level of what an event. Those are mostly what takes place at home occupation event centers. So yes, as was noted, the Barclays live on the property. It's 79.9 acres. The current use, I'm going to turn to Mr. Barclay here in a minute and Mr. Diner and give a little tour of the property. The current uses are farm, they're growing grapes, gardening, canning, their orchard. The big part is their chicken egg farm. They operate about 150 chickens there, which they take harvesting every day. And then the dwelling, they live there. There's a large vineyard. They probably will plant some more of the land with other vineyards in the future. But those are the 2 main uses as we sit right now. So
The 2 main uses would be the winery and the
farm, no, farm.
Farm and residential.
And I note there's a big distinction, right? Because Oregon law has made a distinction between a winery and a farm use.
Yeah.
Right? A farm use is a defined thing under Oregon law, where a winery is a particular statutory land use. So they are even though lay people and probably most other states wouldn't differentiate between a vineyard and a winery, Oregon has, right? Vineyard is a farm crop. It's farm use. It's regular old. You can do it on EFU, period. Whereas a winery is now a more specifically defined thing. You have to have a special permit. You actually have to have them with ATF and various other things when you're producing alcohol. But the winery side to it is separate and distinct, and it has its own application process. Whereas here for a vineyard, it doesn't. Because it's just a farm use.
Okay, but when you said the 2 uses, it's farming and residential.
Farming and residential.
Okay.
So when we're talking about And I bring that up because, okay, so the building, yeah, we have Mr. Barclay, a professional, building designer, and Mr. Diner here. And you'll probably note on some of their CAD drawings and architectural drawings are quite fantastic because that's what they did
Hmm.
for a living. So we have really good, cross sections and pictures that we're going to show you in a minute. But they're also designing and planning with the future in mind. Yes, they would like to eventually, providing the grapes grow well and the wine turns, it looks like it's going to be good, apply for a winery. And so, yes, the building could and is designed to serve the current uses, the current farm uses, the current egg washing, the current orcharding, the current, grapes, canning, the cleaning of the chicken eggs, the storage of all those farm equipment, but also could and is designed to, assuming we got permits and it was all approved, operate as a winery and or a tasting room. So when you see language in there, it's because we have, career long, Mr. Barclay's retired, career long designers planning this out to be capable of doing these other things. And so I point that out. And um, the actual language, one of the last things that was discussed in the staff report based on one of your questions, is that the building be similar to other buildings that are permitted in the zone. The zone is EFU. There's about in Clackamas Code and state law, there are about 40 or 50 types of uses that can be approved in an EFU zone. And so those are the relevant buildings that should be comparable. And we have, and so those are what's similar. The comment made was that having a porch, over the top to block rain or create shade or whatever the purpose of the awning and porch was, is really sort of immaterial. Every building's got an awning. It's the types that are in the area and that are permitted or permittable in an EFU zone. So that's what the code actually says, and I'll go more through that. But I'd like to now have one, Mr. Barclay, could you introduce yourself? And then we get done with that. I'd ask Mr. Diner. We have a PowerPoint presentation that is in the exhibits as PDF slides, exhibit I 1 through 20. And I'll note, Mr. Turner, when you have a chance to review this later on your own, you're going to need to zoom in. As I mentioned, Mr. Barclay and Mr. Diner are experts, and I don't know if this is CAD or how they do these, but they have a great degree of detail on them. You have to zoom in. For instance,
Okay.
there was comments about litter and trash. Well, you have to zoom in quite far in the parking lot. You can actually see the location of where the garbage receptacles around the parking lot and
Hmm.
around the building are going to be. But you have to zoom in a lot. And so there was confusion with Mr. Bateman when he was on this application, and I don't know if that got transmitted to Ms. Fields when she took over. We had to send him the actual PNG or the technological file that could be zoomed in and blown up because I had originally just saved them all as PDFs and they were not as detailed. So there's a lot of, I guess you might, technological detail that can be seen when you zoom in. So I wanted to point that out as we get going here. Mr. Barclay, would you like to introduce yourself?
Yes,
Tell us
sir.
a little
Thank
bit
you.
about what you've got planned.
Sure enough. Thank you, Tyler. And good morning, everybody. Just a couple of quick comments. Our family owns and farms 50 acres of EFU land in Clackamas County. 20 acres of that is the vineyard. We have made significant long-term commitments to agriculture on this property. We're recognizing the reality facing many small farms today, specifically in the current wine grape market. It is often not enough to sustain long-term viability. Being a good steward of the property and being a good neighbor is something we just won't compromise. Ultimately, this application is about preserving agriculture. The ability to host some events will provide the financial support needed to maintain and grow our farming operation. ensuring the land remain in agricultural use for generations to come. Thank you very much for your time and appreciate it.
Thank you, Mr. Barkley. Just to clarify, you say you're farming 50 acres. I'm assuming the rest, because the rest is in forest or other non-farm use.
That's correct.
Okay.
Yeah, that's right. There's 20 plus acres that are all forested and we don't farm that.
Okay. That's what I thought. I just wanted to clarify.
Yes, sir.
Now, Mr. Diner, could you please come on and just walk us through a little bit of a site tour? I know you want to share your screen here, so we can make that capable.
Yeah. So, hi, my name is Ken Diener, Diener, KJD Architecture, address 670 Southwest Tanglewood Circle. And let's see, share screen. Let me see, share screen.
And while you're looking, this is the exhibit several pages.
Yes.
Okay. I've got
Correct.
that on my screen as well. I just downloaded it this morning. I haven't looked at it at all, but I'm going to try and follow along.
Okay. Now let's see here. Why are we not getting? Let's see. Okay. Are you seeing this
Yep,
screen?
now we're sharing your screen. Yep.
Can you see my mouse?
Um, no.
Okay, let's see
Oh, there it
here.
is. There. Yeah,
Yes.
there. I thought it was
This
mine.
one. Okay. So this is the, let me try one more second to try to get to the right screen here.
Yeah, no problem. I have lots of sympathy with trying to deal with technology here during the middle of a hearing.
Yeah. Let's see. Share screen. Here we go. This is the right one. There we go. Right?
Yep.
Okay.
And I'm seeing your mouse.
Okay, great. So this is a the vicinity aerial, and the site is identified here. And again, going to, back to the here's another aerial, a little bit more zoomed in. Here's the residence area down here to the southern part of the site, the orchard and so forth. This is the proposed site for the venue. This is where the sound study, origin of sound, was taken right here, sound source.
Mhm.
And then it was at 60 decibels here with a 1,287-foot drop off. It was measured at 45 decibels here. And that sound study was by Sound Palace. It was submitted with the original application. It's on page 71 and 72 of the original application.
Mhm.
And it's not
But just
labeled in red. There also to the west. There was
right,
one that was to the west there. It's not
right off
labeled
of
in red.
here. Yeah.
That was 55 decibels.
Okay. So again, staff
I'm
is
sorry, I don't
talking
see the 55 decibel.
Ken, if you can go back due west on the edge of the parking lot.
over here.
Yeah. Oh, right there.
That's
Oh,
right.
thank
down
you.
here.
Thank you for pointing that out.
Yeah. Thank you. Yep.
Well, because we're talking about that, Mr. Smith, can you submit the original files, whatever format that was in? Because I can see it, but it is a little bit blurry on my exhibit I, whatever page that is. So when I zoom
Yes,
in, it may not
it
clarify.
should be there. Absolutely, Your Honor. It should be in the file now, but I can resubmit it because again, Mr. Bateman and I went through that.
Okay, yeah, the staff may just need to make an exhibit. I'm assuming I can open it. but so far I'm following along just fine. I just, in case, like you said, if I need to zoom in the future, I want to be able to make sure I can see these things without having to do something to get further information.
That particular picture there is a copy of a much bigger file that is in there for sure.
Okay. So it may be the original may be totally legible. I just want to address that issue before I forgot. Sorry to interrupt, Mr. Diener.
That's okay. That's good. So the staff was talking about ways of thinking about subordinate and to the farm use. There's another way of looking at it when just additional information. So the site plan illustrates the existing home use, orchard, garden, chickens, etc. I just drew a rectangle around that at 3.9 acres. And here is the proposed venue area, including the outdoor ceremony and parking, comes out exactly at 3.9 acres. Plus, you have the 20 acres of existing vineyards. So the proposed venue is actually 4.8% of the total 79.9 acre site. So again, a very small number, so clearly the subordinate a subordinate proportion.
But it says, I thought the code said, or the OAR, subordinate to the residential use, not the overall farm use.
I'll let Tyler.
Yeah,
I'll
I
address
just
that.
wanted to throw that because you phrased it that way. I just wanted to ask that question. We can come back to it. That's fine. We don't have however you want to address it. This is
So
the
it's
first time I have seen this OAR, so I have not had to apply it before. I reviewed it before this, but it's something I'm going to have to consider.
Yeah.
So
I'll cover that a lot, and it's I've got about 5 pages of that in our
okay.
narrative that was put in last night. So
I
I'll cover
figured you
some of that.
would, but I appreciate that.
And so just sort of pointing things out, this was the original submittal A2. I added the green just for clarity, but you can see that the Barclays did a very, very detailed tree survey, and you can actually see the trees proposed to be removed and all of the trees around the venue that are proposed to be saved, and very much a part of the screening for the site. Here's the detail you were talking about, whether the parking lot was identified in dimension. This was A3. You can see all the parking was dimensioned. Here we go. Typical, here's the asphalt area with the ADA. Here's the trash enclosure that was talked about, shown in that site plan. That was A3. And the existing trees that are very well incorporated into the parking design. And these are the light standards as pointed out by staff, these three there. And that one fourth. These were the elevations that were submitted. And we'll go into the character and size here in a second. The floor plan, I added color just for clarity in this presentation, but you can see that, there was a question about staff and separate changing rooms. One of the important things to remember is that the vineyard is an ongoing planted thing. There is staff and workers there, and this changing room, in terms of subordinate use, be used for the people working on the farm and the vineyards, and they will benefit from men, women changing rooms as well. It's not just an event use type only. And then there's talk about the kitchen, cleaning eggs, and so forth. As staff mentioned, there is a very large Exhibit H. We identified all 35 properties around the site, 1,000 feet radius around the site, and all of the uses, and that has been recognized as being appropriate. So let's get into some of the new important things that you were talking about the character of the design compared to local uses. This is a local barn here. You can see the size of these roofs and area. This is a local horse farm that's about about a mile. Here's the address. This is a horse farm. This building itself is approximately 29,000 square feet. Our proposed building is 11,000 square feet on the ground floor. So comparing these roofs to these buildings right here. This is this is an accurate modeling of the proposed building right here from our parking lot. So this is new evidence for you to be able to see this model. And then again, four more images of buildings in the area, very large volumes, large structures, both indoor, outdoor, open, series of roofs and so forth.
And these are all within, walking distance really,
Yeah.
of our site.
Right.
Not even greater Clackamas County. This is just the immediate area.
So these are just local as neighbors. So then getting into we're going to give you 3 EFU approved Clackamas County event centers that have been approved for both scale and use. So here is the barn. This is in the slides. Here's the address. It's an EFU use. It was approved for 400 guests. They do advertise on their website for changing rooms. You can see the size and scale of this building, and here's the rendering of this building. And you can, it's not an exact comparison, but again, you can see very much appropriate. And our building is actually smaller than this one from the barn, quote unquote. Another one nearby is Bridgewater. It was approved for 300 guests, also EFU zone like us. Here is their existing facility, and here's our proposed facility from our modeling. Very much in keeping, in character, and so forth. And here's the address for Bridgewater, again, approved. And then just a little bit further, but not much further away, is this Chateau de Lys, again, EFU zoned on 133 acres, so not much bigger than our existing 80-acre site. It's been approved for 300 indoor guests, 400 outdoor guests. They're building a whole nother arboretum addition for another 300 guests. They talk about with 3 bathrooms and guests. They talk about on their website that they have in their approval been limited to 95 decibels for a sound source, and also similar 10 p.m. They have 100 plus spaces. They identify 115 spaces on their site, on their website. So these are 3 EFU event centers in very, very close proximity, just within about 3 or 4 miles. So I want to go back to the modeling. Staff had talked about topography and so forth.
The
According
modeling of the noise, I assume you mean?
Sorry?
You mean the modeling of the noise, this sound noise?
No, you'll see here in a second. I'll give you this animation, but the street is at around 400, and the building proposed site is about 383. And so there's about a 13-foot drop across this 1,000 feet. So let me play this animation for you. This
Okay.
you won't get in the slides, but here's an aerial view. But I just want to, this isn't helpful in terms of seeing the relationship of the oh shoot, sorry.
Okay.
I moved the mouse and it didn't like that. I won't move the mouse.
I understand.
So here we go again. Okay. So the green area is the vineyards. You can see the driveway coming in from the lower right. Zooming in. There's our proposed venues. Zooming out back from the north, looking south from New Era over the new driveway. And then most importantly, you get down into eye level, and that's what you see of the building at the back of the vineyard back there with the existing trees. So again,
Which direction are we looking here?
Excuse me?
What direction are we looking? Am I looking from the south to the north or the other way around?
Opposite.
you
To
were
south.
looking from north to south.
Okay,
So
that's okay, great.
so here, but when you look at the slides that were submitted, so here are the 5 images that animation showed
Mm-hmm.
you. So here it is here from the era, and I actually in these scenes they're labeled, looking from the northeast to the southwest, looking back. This is the private drive that you were questioning about, and Joe Bestman will mention this. This will be signed as a private drive. This is the public driveway that was approved. Here's
Okay.
the scene from the parking area. And then here is looking from north to south. Here is New Era Road and the approved entry, the existing driveway through the vineyard down to the venue site. And then the home and orchard area is down here through the trees.
Okay, thank you. That helps.
Yeah, and then one thing I added here, again, this is the last slide. Here's my model view. You can see there's the driveway in the lines, person for scale. You can see I lifted it up just a little bit so you have a better view into this. But here is a view from that driveway right here from the middle of the road on New Era. You can see the driveway in the vineyard and then these trees. Here's my model of this tree line right here. And that little white blip right there is about the area that we're talking about in the distance. So that's the character of the venue from the road.
Is that white blip, is that an existing building or is that the proposed?
It's not a building. I think Michael can clarify, but I think there was just like a shelter tent for people when they were
Okay.
working in the fields out there, and they just had a like an awning type, pop-up
Yeah.
thing while they
Yep, that
were
makes
working
sense.
out there. But you can use that as a benchmark.
Marker. Yeah, I appreciate that. Thanks for
Yeah.
the clarification.
Okay. So that if you want, we can move on.
Yeah, go
And
ahead.
again, all of these slides are now in the record.
Okay, thank you, Mr. Diener. So, Mr. Turner, first, before I get into the precise aspects of the approval criteria, I'll point out again that here we're looking at this application is the obviously for land use, state statutes dictate what local jurisdictions can do, counties and cities. Here, the state statute again is ORS 215-448. Okay, that's the standards for home occupations with associated parking. And the language, I'll cover some more of this later, but we were talking about this. I looked up the exact language we're talking about for buildings. And I lost it. Oh, okay, here it is. The relevant criteria is that the home occupation shall be operated substantially in the operator's dwelling or other buildings normally associated with uses permitted in the applicable zoning district. So there we can be clear that it's talking about uses that are permitted, and we know permitted is different than allowed. Allowed means you don't have to ask anybody any permission. Permitted means you have to go before a hearing, get it approved, and then you can do it, and you've got an official government license to do it. And the applicable zoning district, EFU. So that's the actual standard for, the occupation shall be operated substantially in the operator's dwelling or the other buildings normally associated with uses permitted in the applicable zoning district. So that's, I wanted
And
to
Mr.
point.
Smith, I'm sorry, I have a question. I think it's just a different terminology in state law versus the county code. Generally, the county code talks about permitted uses being what I think state law refers to as allowed. And what so the language you're quoting is the state law. So the permit when they say permitted, they mean type 2 and 3 uses.
Yes,
Okay,
because the county doesn't get involved in an allowed use, right?
right.
You get to do it.
Well, their code lists what's permitted. What they use as the term is permitted, but
Exactly.
in the EFU. Great, thank you. Just wanted, as you said that, I had that thought and wanted to clarify.
Yeah, thank you. Okay, so then the staff report in a few places states it almost as if it's a deficiency that they say the applicant didn't have objective evidence. Well, objective evidence is great, but not all evidence is particularly in land use, not all evidence is objective, right? The land use is known for subjectivity, substantial, you know, um, minimal. What are the other ones? Mitigate, not have a substantial impact. There's a lot of, and it's reasonable evidence that a serious person would rely on in their serious affairs, right? That's the
Hmm.
actual standard. So it's not objective. There's a lot of opinion. There's a lot of um, pieces of evidence that add to the weight in making the decision. So in the places that talked about, staff had concerns because there wasn't objective evidence. Well, objective evidence is like a measurement, a weight, a distance, a
Hmm.
count the parking spots. That's the objective evidence. And we have that where it's necessary or even available. Some things like it's not a substantial impact or not a substantial detriment aren't countable or weighable or measurable. They are by nature subjective criteria. So I'll mention that just as a preliminary. Um, so you'll notice in um, page 3 of our narrative, and I'll point that part out, is the distinction and the explanation of why the agritourism doesn't apply. That comes under ORS 215, 283, which is which is the winery criteria. Um, so first I'll talk about the staff's, I think their biggest concern, and I want to address that first. We did, after staff made those comments, elaborate on and went to great detail to analyze both state law, state administrative rules, and the county's code on the Factor 4 Oregon Administrative Rule 660-33-13014 on the accessory, subordinate, and incidental. So I'll go to that next, but uh, so that analysis is on page 11. So you'll notice that subsection A of that asks that the scale and intensity of the use is no more intensive than the limitations and conditions otherwise specified for the use in OAR 33, 660, 33, 120, which Your Honor is probably familiar with is the chart, right? That's their table that says
Hmm.
which sections of the OAR apply. Here we have it's an R category, which means that has to be approved through a hearing, and then sections 5 and 14 apply. Okay, so 5 and 14 then create the limitations and conditions specified for the use in OAR 660-33-120. Right? That's where it refers you to. Those would be the source of the limitations and conditions. And this is all explained in detail on page 11. So then we go to Your Honor's probably dealt with OAR 33-130 subsection 5 a bazillion times. That's the uh, substantial impact test, right? Not
Hmm.
the farm and forest test. So, anybody in land use, and Your Honor probably knows that intimately well. And we've got our surrounding area analysis that staff said covered those, talks about those, and that type of a process where we identified all of the surrounding uses, residential, farm, horse, all of those in a circumference all the way around the property, and it's all explained in Exhibit H is our surrounding area analysis, is also on um, Exhibit B. It's on Exhibit I-9 as a listing of all the properties that were studied, and it's discussed in the surrounding area analysis memorandum that's part of Exhibit H. So those were all analyzed all the way around. So that covered OAR 660-33-130 subsection 5. Next is OAR 660-33 130 subsection 14. So 14 is the one that uses the new terms, is really the new part of the process. And that is that the use is accessory, incidental, and subordinate to the primary residential use of a dwelling on the property. And so this is where one set what staff talked about didn't have a lot of evidence, wasn't objective evidence. Here, again, the proposed use, the primary use is obviously the residential residence, right? The residence is 365 days a year, is 24 hours a day, 7 days a week, constant. So we analyzed then what accessory means, what incidental means, and what subordinate means. So those analysis is on page 12, 13, 14 of our narrative. Accessory does have an actual definition in Clackamas's code. It's accessory building or use is the definition, but that's actually in the code. And you take a look at that, and it's always I guess if you ask Mr. Webster that created the dictionary, it's not ever a good idea to cross-reference other words in the definition. But the definition of accessory does have, subordinate as a part of it. But it tells you how much these words are sort of the same. And they even use incidental in one of the other definitions. So accessory, subordinate, incidental sort of have some overlapping definitions, whether it's 100% overlapping, 90%, or 1% is probably up for debate, but we've got some definitions here. So the accessory is defined, and that simply it talks about that it's in ultimate, my conclusion here, and I think you will read it, I'm sure, is that it means it's not the primary use. That it's not the that there's a different primary use. The primary use here obviously is the dwelling, but we're also talking about EFU land. So farm use is probably if it's not the primary, farm use is also a secondary use on this property. And then the accessory use, and we talk about accessory because accessory is like accessorize or secondary to. Well, you can't have our requested use, a home occupation to host events unless you have a home. You have to have a dwelling. So that's the primary. That's the precursor. You can't have a home occupation to host events if you don't have the home. So the home is the primary. The home occupation to host events is the secondary. You can't have the secondary without the primary. So that's, I think, how that applies here. Incidental. Incidental is defined in that same administrative rule, or not, shouldn't say defined. It's used in the same state administrative rule multiple times. Most probably influential or applicable and analogous to our situation is they use it in terms of with golf courses. They talk about, and I've cited it in there, how incidental is used in relationship to golf courses. What is incidental? It talks about, is that the end? Yeah, that's it talks about when for a golf course, maintenance buildings, cart storage, repair building, practice range, driving range, clubhouse, restrooms, lockers, showers, food and beverage service, pro shop, practice or beginner's course, are all accessory uses. And then it points out that a swimming pool or a tennis court would not, or incidental, those are all incidental uses. A swimming pool or a tennis court would not be incidental uses because they're a different nature. They're not a part of a golf course. Well, here, the home and the home occupation, having a building for a home occupation to host events is precisely the incidental. That's what you're trying to do is host events, and you have a building to host the events in. So I think the comparisons there with the golf courses is very instructive as to what incidental should mean. And even in that administrative rule, they talk about farm stands. Farm stands use an example and a sort of a threshold of 25%. They talk about, if you're selling additional things that are not I guess produce probably in a farm stand. I don't know the definitions, didn't go that far, but can't make up more than 25% of the farm stand sales. So when you're talking about what you're selling, the 25% threshold. Um, so I have an analysis on that. Here, our building will obviously be used as a part of the event hosting. It will also be used for egg cleaning, production, canning, storage of farm equipment for farm workers, bathrooms to go in and get out of the sun, the harvesting season, these kinds of things. So it actually will be multiple use. So when you start factoring in and saying, okay, well, if there's an office that was pointed out to be in there, so you're using the using it for the home occupation, using it for your farm, you're using it for your chicken operation, you're using it for your, for your vineyard workers and that kind of stuff. That's sort of the same as any other barn farm. Yes, this one's new. Yes, they want to, potentially be able to have a winery in the future, but just because this one's new and looks nicer doesn't mean it's different in size, scope, nature than all those other buildings that are what you talked about within walking distance. Um, so we talk about in there, we have some ratios of square footages, acreages, whether you want to break it down by 84 uses a year or 3 uses a week, the time amount that's used. Ours are get into like 3% of the time, or I think it was 23% of the days of the year could ever have an event. Or the acreage was a little more than 3% of the total acreage, something like that. So we start breaking it down and doing various different methods, whatever kind of mental gymnastics you could use to sort of analyze that as a larger piece of the property. You can see it's a pretty small percentage of the total use of the property, which is an EFU, dwelling. Obviously, in EFU land, the technical nature is a primary dwelling on an EFU land, right? You have to apply and get special permission to have a dwelling on EFU land. So, in reality, I think, yes, the code says the primary residence or primary dwelling, but the farm use is also, taking up a lot of the use of the land. So and I point that out because we talk about, those definitions have primary or predominant uses in as a part of them. And here you can see, I list out what the primary or predominant uses and analyze that. Storage building is necessary, washing station is necessary, egg cleaning is necessary, egg packaging is necessary, processing room, bathrooms for the farm workers, places for employees to get out of the sun, and for the owners to do the same thing are customary, necessary, ordinary uses in farmland. So, and I cover subordinate is on 14. I didn't talk too much about that yet, but I think I already, essentially covered that. Staff even used the similar definitions as us, that submissive to or controlled by another authority. That seems like a perfectly legitimate definition. There wasn't much in state law or state code or county code. But again, here, home occupation is required to be operated by the owner of the property. There's your authority. It's subordinate. They're in charge of it, the residential owner of the property. If for some reason it stopped being used as a residence, bam, you fall off a cliff. You can't use it as a home occupation anymore, right? That's the submissive to or controlled by aspect of this. So that's all explained in there. With respect to the new administrative rule. And I went exhaustively through that. Staff had mentioned, and we had a nice conversation about that's the first time the county had processed that. And I think using the Oregon administrative rules, the other uses of that, as Your Honor would know, the normal use of finding a definition of something is text and context, right? And we're pulling that same word out of the same administrative rule and using the examples um, from that same administrative rule and the county's code and the state's definitions is very good text and context. And under, using that, if that's the meaning of that through those text and context, then we meet those criteria. So, and I know the, I think that's a good place for Clackamas County to start in and analyzing and applying this new, state administrative rule. So next, I'll get to the traffic impact study. We have Mr. Bestman, and his is in the record. It is exhibit. We can point you to that while he gets teed up here. His traffic impact study is exhibit A. Mr. Bestman, I'll hand you the microphone for a few minutes here if you'd like to go through that with us somewhat briefly. Mr. Turner, I know there's not a lot of there's not a disagreement on the conclusion with staff on this. So I think that staff had asked for some more information, had pointed out where they might like some clarification, and so we're trying to address some of those.
Well, thanks, Tyler. Mr. Turner, for the record, Joe Bestman, Bessman, professional traffic engineer with Transite Consulting, address of 61271 Splendor Lane, Bend, Oregon, 97702. So I've been involved in traffic studies for a wide variety of event type uses, from multi-day music festivals to dude ranches, pumpkin patches, farm stands, churches, you name it, I've probably been involved in it. And just to clarify some of the comments in the staff report, these are not an ITE based use where you can go to a lookup code and say it's going to generate this many trips. As Mr. Tyler mentioned, when you're looking at an event center, you're developing these windows of time, these windows that an event could happen if Mr. Barclay is fortunate enough to have someone actually attend this event. And then you have a maximum attendance. It doesn't mean that every event is going to be at that maximum level of attendance. He's very lucky if they are, but there's usually a very wide range of people that attend these events, how often these events occur. What you find is there's a lot of seasonality. Usually more events happen in the summertime in the Northwest. Fewer events happen in the wintertime. Most people don't schedule an event for the PM peak hour, which is when most of our county's transportation planning is developed, around that busiest hour of the day when people are driving home from work. They're usually off-peak time periods. And so what all this means is when you get to a trip number in a traffic study, we're looking at the peak hour of that multi-hour event, which is either going to be the hour when people are arriving or the hour when people are departing, because the intervening hours are even also usually pretty dead in terms of trip generation. When you have an event center that can hold up to 200 persons on it, that doesn't mean you're going to have 200 cars either. What you find for these types of uses, especially in rural areas, is vehicle occupancy is usually 3 persons plus or minus, right in that range. So you have much fewer cars. So there was some questions in the staff report about the actual impacts of this site. And again, what I try to do in my traffic report is say, okay, worst case scenario, the busiest hour of a weekday, if you took the maximum attendance, added those together, how does the system work? And it works really well. Okay, now if you take the Saturday, the busiest hour of a Saturday, and pair that with the maximum attendance, how does that work? And again, it works really well. There was again some confusion about the New Era and Central Point Road intersection. What I showed in my traffic study is that intersection that was just recently rebuilt by the county meets the minimum eastbound to northbound left turn lane warrants. Is typically, as a traffic engineer, what that means is that's when you start to consider adding a left turn. With the location of our site to the east, we have 0 trips that impact that eastbound to northbound left turn maneuver. And so in my report, what I had written was there's no nexus, there's no rational basis for us to build a left turn lane for a maximum event that we said no trips and we have essentially no impact at. So hopefully that clarifies that comment in the staff report.
Thank you.
Specific to the transportation criteria, is the transportation system safe? And just to hit on those points, yes, the northern axis is where all the guests and patrons are going to come in. It's It's a location that's already been permitted. The conditions for that access have already been achieved by what Mr. Barclay has constructed. The county's engineer has confirmed that. The access is situated in a location where there's clear sight lines to the left, there's clear sight lines to the right, meets all the intersection sight distance criteria. We do plan to put wayfinding signs at that entrance. Those are going to be, per the allowable sign code and, outside of the clear vision triangles, of course. But there's no safety issues. This driveway along this road. We do have that separate private residential access to the east that's going to be signed to make sure that guests and patrons of the events aren't using that. I believe there is some way for emergency use of that if it were needed, but that's the only situation where that would be affiliated with any type of event. So I think, is the transportation system safe? Yes. And I think even in the county's own review comments, where they say the proposed access, on-site circulation, and parking appear capable of accommodating the anticipated traffic associated with event hosting, and the use is not expected to adversely affect the safety or operation of the surrounding roadway system. We agree with that finding. We think that's the right approach. We think we meet that criteria. I did see one comment that came in from the opposition that cited a concern about pedestrian and bicycle safety on New Era Road. I guess on the first point for pedestrians, this really isn't a road that I've seen or am aware of people walking down. And unless you like walking in blackberries and in a drainage ditch, there's no shoulder to this road. There's not uses that are really conducive to pedestrian activity. So that's something I really didn't see happen. The traffic counts didn't capture anyone. If it does happen, I'm sure it's very infrequent. Cyclists are another story. There are more cyclists out here because they're fairly low volume roads. And these are windy roads with vertical, horizontal curves, a lot of no passing signs. The county has signed share the road. Because there's no shoulders, the cyclists are in the road. With the type of event traffic here, which is similar to other uses on this same corridor, what you see is it's almost entirely made up of passenger vehicles. We're not using oversized, overdimensional vehicles. There's not going to be more farm combines or even the equestrian, type uses with long horse trailers or anything else. So yes, patrons that are going to the center might have to follow behind a cyclist in a no passing zone, but that itself is not an inherent safety issue. So pending any questions from you, that really concludes my transportation component.
Thank you, Mr. Pressman. I don't have any questions at this point.
Thanks.
I have
Thank
a
you, Mr.
quick
Pressman.
question for the traffic engineer, if that's possible.
Sure.
One of my questions looking at your report was again, comparing it to residential use of the property. Can you share what a normal trip generation of a 4-person home is anticipated to be?
I can. I guess I don't understand why that would be the comparison. If I look at EFU uses, the ones that are allowed outright by state law, I mean, you have churches and cemeteries and dog training and dog boarding and a wide variety of other uses. So I'd probably defer back to Mr. Tyler, but yeah, it's going to be, more intense than a single family home, of course. But, you're also not seeing the level of trip generation and types of truck traffic you might even see from an equestrian center like you have next door. So I'll defer to Mr. Tyler on any further comments on that.
No, thank you,
you.
Mr. Pressman. Appreciate your expert analysis. Okay, Mr. Turner. Next, I will. I guess one of the questions on the sound study. So I'll point to that first, so we can cover that. Exhibit C was the written sound study, and C2. So if you look at that, now what we've talked about here, and we've even staff had, I think, some questions on this, and they, that's certainly a criteria. So it's good to get these questions answered. But the study was 60 decibels at the source. Mr. Diener had shown where that was, and note that was on. We can go back to Mr. Diener. I'm going to see if you're it was Exhibit I-2. Maybe I'll just share my I-2. And you'll see that the sound source is on the what would be the east side of what would be the dwelling. So the existing readings on 60 decibels from here due west and to the northwest, which are the closest actual neighbors. So that's why these are and they are the property boundaries, which is the criteria. To the east is much farther from somebody, and you have New Era Road in between there. So it's much farther out if you go to the east. But it's behind the what would be the building. So it would be even more dissipated there. So this Sound Palace Design in Exhibit C did that study of the volume there, and what we propose is that the exterior sound only be ceremony, and it only be capped at 60 decibel. If you cap the exterior sound at 60 decibel, then it's I guess pragmatically and probably technologically impossible for it to be higher than 60 decibels when it reaches the edge of the property. Um,
Sure.
and then the interior. And so then we also had Sound Palace Design talked about the interior design, and that's obviously a little more complicated. We talk about using directional speakers on the going back to the exterior. Talk about directional speakers, so sound is directed down, so it stays more localized. It then reflects, in theory, off the ground and starts dissipating much faster than sideways speakers. And it would be, weddings is usually a small amount of music, maybe somebody singing a song. That's realistically where the sound would come from, if any, coming from the outside. And then the indoor. There's soundproofing measures, inside the building, soundproofing walls, having doors closed after certain hours, which is 7 p.m. Conclusion of events by 10 p.m., which matches with the Clackamas County noise ordinance. Um, and the mitigation that's put in through the construction standards and through those timing standards, through the type of you what would you call it? Electronic speaker, electronic music control systems have those capacities now where you can know what it's producing in terms of volume, and decibel rating, I guess. So all those are listed in the Sound Palace Design on Exhibit C. Can be conditioned to continue to match that. As pointed out, that's probably way less than what you know could be approved. We saw the one advertising that they had up to 95 decibels capability. Must be a marketing thing that they use. But depending on the size of the property, which here we have a very big property, size of the property, can in theory host and accommodate much more noise. Here we've got 79 acres, but that's all we're looking for there. Um, then, with respect to the dwelling analysis and any impacts on dwellings and residential uses in the area, staff had apparently, maybe couldn't find that, maybe didn't see it, or maybe just thinks it wasn't what it was. But there's already in the record prior to the submittals last night, specifically on Exhibit H, the state law and LUBA approved type of analysis on this. Substantial impacts on farm and forest didn't used to include analysis on nearby dwellings because those are not farm or forest uses, and obviously that's changed. So we have that actually in there in that report. Is most of the surrounding dwellings are what we would call hobby farms, right? When you've got 5 acres, or 2 acres or 4 acres or 10 acres, you essentially by default become a hobby farm because you're probably going to have some stuff out there. So that is analyzed in page 47 of Exhibit 8, but it's also we've added to that and added more to address some of staff's comments in our narrative that was submitted last night. So point that out. Um, the lighting plans are in Exhibits D and J. There are all the technical term for those we know is because it's called the building side shield, I believe. So they're all shielded so that they direct their light downwards, and then cannot or not cannot, but do not show the light from off the normally it's a property line in a commercial setting or residential setting. Here it's just going to be the parking lot and the building footprint. But those shielded lights direct the lighting down so that you don't have one light pollution nor any annoyance on any neighbors. And here it's pretty far away, but that's one of the more modern types of criteria, and those exhibits show that that is the feature. Staff had talked about not knowing the extent and design of the features. So we've added Exhibit J, which Exhibit D was already in there, and it had the actual lighting and some specifications, I think particularly related to the building. We've added J, which would be the parking fixtures. So that's been added. With respect to the water, both here we have water, we have well, we have stormwater feasibility, and we have septic. The well water and water capability is on Exhibit E. It's the actual well report, the well permit numbers. Oh, I'm sorry, that is not E. Yes, E is the well. And there were some questions asked, and staff had asked some of the Clackamas County, or no, asked the state water master about that. And so we have added in some additional exhibits, which is exhibit number. I believe that might have been K. I'll get that exhibit number for you. We added in another exhibit showing the amount of water that is used for typical types of events. The staff had asked if this vineyard is irrigated. It's not irrigated, so that substantially decreases the current use because they're operating under a permitted well with not a registered water right. So we fit under the exemption. The exemption quantities is the reason I mentioned that. It already has an approved septic system. Exhibit F covers that. And as staff pointed out in the staff report, you may see this. One of the, I think, 4 or so places where they thought we didn't meet the criteria, but we had an expired feasibility. Our feasibility is apparently supposed to be within 12 months of the filing of the permit. Ours was with 13 months. So we got a new one on the 7th. That was submitted last night. There's a new stormwater feasibility assessment that is in the record, and that is exhibit. I'm not. I lost some of my exhibit numbering here.
I can find it, I'm sure.
Yeah, it was submitted last night in those. So, and then staff had asked about trash receptacles and litter and how we're dealing with that. Yeah, anything that's created by an event will be cleaned up by the owners. We have the traffic receptacles or the garbage receptacles were on the original A2. Exhibit A2 is the one that needs to be zoomed in. Ken, can you help us out again and zoom us in, showing the parking lot again and the trash receptacles around? Okay, so garbage containment, has been planned and is there. And there's a plan for, cleaning up. We've shown that Cahoot Waste Service has provides waste service out there. They're the main provider in this area. And we've got their, the evidence there is exhibit. Pull that one out because I know that one. That's exhibit G, that they provide services out there, and the plan is already written in and shown on the site plan. Next. To point out that the goals and policies of the comprehensive plan are, a goal and a policy are become an approval criteria when they require something specific or concrete. When they either prohibit something, they're a prohibition, and when they demand something, they become a requirement. Here, the ones that were referenced in subsection N were, for all intents and purposes, recommendations, limitations, and directions to the county on how they adopt their code provisions. So it says areas generally in parcels of 20 acres or larger, areas primarily in agricultural use, areas predominantly in class 1 through 4, other uses, in soil classes different than NRCS. So the comprehensive plan policies, talks about encouraged, and conflicts are not allowed, those kinds of things. There aren't what we would call formalized approval criteria that you could say, or that LUBA or the Court of Appeals could say, is this met or not met here? These are guide, if you want to call them guide marks. These are like the state goals and the county comprehensive plan. The code is adopted pursuant to those, and compliance with the code is sort of deemed and thought of as compliance with those, unless again they create some concrete affirmative duty to do X or prohibition on doing Y, and those ones do not. Yes, so some addition on the signage. Mr. Barclay had already obtained a sign permit. So the reason we just submitted the same sign permit because that had already been approved for this site. Now, we're fine with changing that and minimizing it. The staff is correct that the code actually has a 32 square foot provision in it. And I think that would be best dealt with a condition of approval here. Because if him already, and we haven't analyzed whether him already having an approved sign for some other reason might mean he can keep that sign. I don't know that. But we'd be fine with submitting a new sign permit, either whether it complies with the 32 square foot, or he can keep that old design that they already approved for whatever use that was. I wasn't a part of that. I don't actually know. We'd be fine making that adjustment and making that conform to what the county wants. If your honor thought that having covered porch, or those what you can see awnings is a big deal, those could be conditioned and removed. I think obviously it would change the design some, but as a practical matter, hosting events, whether you have shade or not, it's just probably more of a nicety. Oh, we did have one of staff's proposed conditions of approval. We had a comment on it. We did not. It's Michael and Linda Barclay technically, so we would suggested taking out the direct name on
Oh, is this in the condition
condition
where
7. Yeah,
applicant have to live there?
yeah. Obviously, for home occupation, if the property ever got sold, the new owner would have to do their own thing and whatnot. But if it's Linda or Michael, just take out the name. So it's the operator of the home occupation has to be the resident there, which is what the requirement is. Did your honor have any questions for me? we would like to save time for any kind of rebuttal.
Yeah, sure. Let me write down that note about the name in the.
That was staff's proposed condition of approval 7.
Thank you. That's what I was looking for. I had a couple of questions or requests. Let me get back. The noise study, sound study. I don't have any real issues with the indoor. Well, I have a question about that, but let me get the outdoor noise. Staff noted that 60 decibels is, I think it's talking, it's fairly low. Whereas someone singing, someone playing an acoustic instrument is likely to exceed 60 decibels. So even if you're limiting your amplifier, those noise sources could exceed 60 decibels. So that staff recommended a condition that no outside music be prohibited. I think that's what they said. Um, so I just wanted to, if you can clarify that now, or if we want to hold the record open for any reason.
Well, I do agree with you that 60 is probably too low. That's not really, I don't, that, that was proposed by us. That was the measurement that was taken. I think 80 is more realistic at that site. But we do have, proof and, a measurement that if 60 is played right there, it will not be more than 60 going off of the property.
Sure.
So objective evidence that 60 meets the technological criteria of not
Absolutely
being
agree.
over
But
60.
someone, how do you limit it to 60 with singing and acoustic music?
Well, with
What's
the
proposed?
yeah, if it's acoustic, then you'd have to have a sound meter and monitor that. And that'd be monitored. We put in there that we'd have monitored. If it's something that's played, the device could be electronically controlled to
Yeah,
be
assuming it's an
volume
electronic
control.
instrument.
Right.
Yeah. Okay. Um, let me write that down. Oh, inside noise. This sound study says it's met with the doors closed. It's well below the standard. But the doors will be open until 7, according to what you proposed, and also people going in and out as they come and go. Some people leave early or arrive later. If the sound is playing inside when those doors are open, is there evidence that it won't exceed the limit, 60 decibels?
Um, well, off property, they would need to be emitting 60 decibels out the door, right? So
Right.
that's where the sound transmission class ratings and materials would be used, the soundproofing.
But when the doors are open, that is less effective because the sound could travel right out without being blocked by that noise mitigation inside the building.
That's where they talk about the door thresholds in point 4 there. And point 5 is after 7 o'clock, door will remain closed.
Mhm.
They have the building itself has multiple entrances and exits, if you can see from the rendering. So they would have them not leave from where the source of the noise, I don't know the floor plan super well, but you wouldn't leave right from
Sure.
the dance floor.
But how are you? There's no proposal to do that. And I'd need specifics on either that is, it won't, if the doors are open, it's not going to have that impact. It's not going to exceed the standard. Or we're going to keep these doors closed when music is playing and limit access to these doors, and it will meet the standard.
Well, point 1 here has the music policy that it will be monitored. We could have a sound meter on site at all times would be the easiest way to condition that, is that there's a working sound meter on site at all times, that you can test it.
So I'm just kind of spitballing how that would work. The, I, I assume your sound expert could determine what the maximum outdoor sound could be outside the building that wouldn't exceed 60 decibels at the property line. So they could put a monitor outside the building where if it exceeds that level that's been chosen or identified, it would cut the volume inside automatically.
Um, Usually those are handheld. I mean, what I was talking
Yeah,
about
so
is
that's the problem is people are going in and out. That happens frequently. So nobody's going to be, unless somebody's standing there monitoring, how are you going to enforce that? Unless there's an automatic cutoff when a door is open. So additional evidence on that issue would be helpful. Um, Given you've got a buffer, so to speak, because you're I don't remember the exact numbers, but you're below 60 decibels. So I think it could be met, but I just need evidence that it will be met.
okay. Um,
And if it's in your noise study already, you could point that out in your final argument, or I can hold the record open. We could submit additional evidence on that issue.
sure.
Um, Given that things came in last night, I'm going to hold the record open for the public and staff to review and respond to Exhibit 11. Um, and I'll give the applicant a week at least to submit a final argument, obviously. Um, but another option would be to hold it open for a total of 3 weeks, one for new evidence from anybody, including the applicant, if you wanted to provide more on that issue or anything else. One for anybody to respond to whatever was submitted, and then the applicant's final argument. But that's up to the applicant.
And if it was left open for staff or any opponents to submit anything, we'd want a rebuttal period after
Sure.
their final submittals. Right?
Yeah, so you want the opportunity to submit additional evidence and rebuttal, is that correct?
If somebody else is going to have some submittal,
Yeah.
we'd want the final response. Yeah.
Okay. Yeah, so that would be fine if we'll address that at the end. But I guess are you requesting the open record period to submit additional evidence?
Yeah, I think we could talk to the sound engineer. He's not here today,
Yeah.
and get
Okay.
get that explanation.
That would be helpful. Then back to my other question.
Is there? And then I would point, if I could, sorry, Mr. Turner.
Oh, go ahead.
Sound engineer prefaced all of that, and I didn't read this before, that their design here was to ensure that the noise from the event does not exceed the acceptable levels, yada yada.
Right.
So they had proposed these 5 things as their evidence and reasoning why it wouldn't or why it wouldn't exceed the acceptable levels. So I'd have to defer to them on if or why that's
Absolutely.
somehow
Yeah, if they
not
can-
adequate.
If they can, your expert can say, yeah, even if the door is open, it'll be fine, and support that. But that would do it. It makes it easier if I have the evidence in front of me. I can cite to it. Ms. Fields, I see your hand. I'll get to you in just a second. The other issue was the other facilities that you cited, the barn, Bridgewater, and Chateau de Lille. Chateau de Lille, I reviewed, and as I recall, I don't know. The Arboretum was a big issue. I can't remember if I approved it or denied the Arboretum specific. I approved the application, but there were some conditions that some of the proposed things that they were going to do exceeded the code, and I denied those. I thought the Arboretum was one of those, and they may have come back and got another approval. It was demonstrated it was, or I may just be misrecollecting that. I can grab that decision. I have it right in front of me. I would ask staff to put it in the record because I'm going to review it. The 95 decibel limit, I'm assuming is inside the building because noise was also a significant issue at that facility. And the 400 guests, I think clearly exceeds the code. So I don't think that's actually allowed. They may be what's on their website. They may be operating illegally, but I don't think that's a precedent. Um, just some observations. But I'm not familiar with Bridgewater or the barn. If the applicant or staff can provide the approval of this decisions approving those two uses, it would be helpful. So I can see how the restroom facilities specifically and changing rooms were addressed in those decisions. Um, that I may agree with that reasoning, but I'm not familiar with those decisions.
Well, Brightwater was one I did. I've done um, multiple of these home occupations for hosting events in Clackamas County. So
Yeah,
that one went all the
I
way
can get the
to.
decision on those. I can review the reasoning and see if it's comparable. And also, I would note that none of those were subject to this new OAR. So as far as that, I I understand you're mostly submitting it regarding the impact of this facility comparable to other previously proposed facilities, but I don't think they are relevant for that new OAR standard. And it's again,
Yeah, we were submitting those specifically, just to clarify that we were submitting those to show the similarity of buildings that are and have been permitted uses in the EFU zone.
okay,
Right. So
thank you.
most of those were bigger, and were of similar rectangular structure. And I know
Sure.
Brightwater has bathrooms in there. I know there's changing rooms. So
Okay.
you know.
I look forward to looking at reviewing those, just for clarification. Ms. Fields, did your question get answered? You had your hand raised? You're
I was
muted. There you go.
circling
Sorry.
back to the open record period and the clock.
Yes, I'll get to that at the end.
Okay.
If we're going to hold the record open, I will need the applicant to extend the 150-day clock, and we can look at specifics then. I am a little concerned. I have a vacation coming up, and so I may need to request this. I'm hoping it won't be an issue, but I want to. We'll address that at the end when I have a calendar in front of me, and I can give you specifics. Okay, that was the only questions I had, Mr. Smith. Is that it from the applicant at this point?
Yes, thank you. We'll say, and again,
Thank
we
you.
probably will want to respond if there's anything else new.
Okay, with that, I will go to public testimony. Last I looked, there was just one person. Oh, there's now more. Is there anybody who'd like to say anything about this application in support, in opposition, or with questions or concerns? If so, please click on the raise your hand button and we'll call on for testimony from those raised hands. So I'm waiting for anybody to raise their hand if they have questions or want to say anything about this application, because I am not seeing any raised hands yet. We did have some. I heard somebody for a second, but I think it was the boyfriend.
This is Damaris. Can I have a chance to talk?
Yes. Who is this?
I'm Damaris Smith, SMYTH.
Okay.
I'm at
Just,
116.
sorry. Just a minute. I had to get my.
Yeah.
Can you repeat your name again?
Damaris, DAMARIS, Smith,
Thank you.
SMYTH.
Thank you. Go ahead.
I'm over at 11638 South New Era Road. I run the equestrian facility here.
Okay.
And I can't speak to the criteria for this venue or for really much of what you guys have been covering. I just wanted to say that from my perspective as a neighbor and running my business here, that the noise and the lights don't pose any concern to me, my business, my clients. I think the traffic would be beneficial. I've got my sign on the road front, and people knowing that my business is here is not a bad thing for me. And then the building and the drawings I've seen of it, I think the aesthetics are much nicer than even the barns I have. So, and the location of it does not inhibit our gorgeous view of the vineyards and Mount Hood. And I think it would do service to the area. I think it would look very, very nice aesthetically. And I just don't see a problem with having a venue next door. I kind of like the idea, to be honest. And I think my clients, we'll be happy with that too. So.
Okay. Thank you, Ms. Smith.
Okay, thanks.
I am not seeing any other raised hands. Anything further from staff? Any response from staff?
Not at this time.
Okay.
While the open record is open, I would address water usage based on the evidence submitted in Exhibit 11. And
Okay.
I'll look at their narrative as well.
Mr. Smith, let me grab my calendar. I'll give us some specific dates and then I'll let you wrap up
Okay.
and get a chance to respond to the open record issue as well at the same time. So what I'm predisposed to do is hold it open for a total of 3 weeks, hold the record open. So today's the 9th. So that would be April 30th, the end of the 3 weeks, which gives me 2 weeks to get this decision out before I leave. So that's not going to be an issue. But is the applicant willing to extend the 150-day clock for 2 weeks because the applicant's final argument doesn't count against the 150 days to allow for that open record period?
Yeah, I think that's fine. Like you said,
Great.
2 weeks.
Yeah. And if you submit something in writing to that effect during that first week, that'd be great.
Sure.
So that was the only issue. Anything else the applicant wants to add? Oh, I see a raised hand on the panelist. Second. I have to get
It's
back to
staff,
page 3.
Joy Fields. I have my hand up.
Oh, thanks. I didn't look up there.
I would request that the first open record period be open for 2 weeks so that I have time to look at Exhibit 11.
Exhibit 11.
So
What is Exhibit 11?
it's the one that you submitted last night.
Yeah.
Well, with all due respect, I mean, today was our hearing. I don't want to leave the record open to just, keep sort of a blank check and the clock running on my clients. If we want to submit, sound evidence, other event permits, and stuff on water, that seems like the most reasonable because those were what we were talking about. Those 3 topics seem to me what the open record should be about, and only 3 of us.
Anybody to respond to any issues. So new issues can be raised, but during that first week. But
only by participants, right? And we only have 3 participants.
Well, they don't have to have said anything at the hearing today or participated already. Anybody who's the open record is similar to the hearing. Anybody can say anything they want to, as long as it's relevant. So, but I agree. I think a week is standard for anybody, applicant, staff, and public to have the same week to review anything new that came in either during this week or during the second week. So I am going to limit it to a total of 3 weeks. I appreciate staff's desire for more time, but that pushes into I would be out of town for 3 weeks, and that could significantly delay my decision here. So I'm going to limit it to a total of 3 weeks.
That is fine. Can I have a few moments to talk about water? And then I won't need to submit anything in writing.
Okay. Mr. Smith, do you have any objection to that? It seems like it makes
No, if that's the sort of stipulation, yeah. I mean, I'd like to get.
I'll give you the chance to respond.
Finished up, yeah.
Yeah. Go ahead,
Okay.
Ms. Fields.
So in Exhibit 11 that they submitted last night on page 51, they identify usage of water per guest based on different time frames. Based on the event hours being from 9 a.m. to 10 p.m., staff would look at the use per guest at 15 gallons because that is what the evidence that the applicant provided indicated was the usage for an 8-hour event.
15 gallons per guest?
Per guest.
Okay.
So 15 gallons per guest means that for an 8-hour event, that's 3,000 gallons of water used for that one day. That same page indicates that for each member of a family residing in a residence, they estimate that it's 60 gallons of water used per day. So for a family of four, the water usage over the entire year is a, based on the evidence that provided by the applicant, it's 86,400 gallons of water used for a family of four over 1 year. For 80, I used 85 events in my calculation, but the applicant indicated during the hearing that it would be 84 events. So 84 events for 200 people using 15 gallons of water would be, wait a second, 84 times 3,000 gallons of water is 252,000 gallons used a year. So when we look
The
at
total combined residential and event facility.
no, just event facility
Just event, okay.
to compare with the 86,000 gallons used by the residential use.
Right.
So when we look at the intensity of the use for incidental and subordinate to residential use, the staff report identified water usage as a concern. And I wanted in the record to use the calculations based on the evidence in Exhibit 11 to highlight the amount of water used by the events for compared to residential use.
Okay. Thank you.
And that is it. Thank you.
Thank you, Ms. Field. Mr. Smith, anything?
Yeah, sure, Mr. Turner. I just point out in this, with that the exemption that they have for their well, the amount of water, they are allowed to use 5,475,000 gallons per year.
Because it's 5,000 per day, I think. Is that what it comes out to?
15,000 for
15,000, okay.
domestic
And it
use.
was a 5.
So when we're talking tens of thousands or whatever the concern was, we got 5.5 million that are available for the domestic use.
Yeah, I understand, but she's arguing that it's the incidental, no, excuse me, the volume of water used for the event facility is much, much greater than the volume of water used for residents. And that relates to the incidental subordinate issue. And I'll consider everybody's argument on that issue. Like I said, this is the first time I've had to apply this one. And I have to, I'm balancing here, trying to figure out what the state intended when it adopted this, because event facilities are allowed up to 300 people, I think is the maximum. How is any 300 person event facility with, operating at the maximum number per year that it's allowed? What residents can possibly be subordinate?
None would be approvable
based on these criteria, the issues the staff has raised. So that's what I'm considering. We're looking forward to arguments on that issue.
Well, and I think you're right there. None would be approvable if that. I mean, and again, staff seems to repeat that assertion that the event would be taking place from 9 o'clock in the morning till 10 o'clock at night. And
I understand that. And you addressed that, your argument well there, but that's the evidence that staff has, because unless there's some limit on, then the events are limited to 4 hours, 2 hours, but something, so that it's more comparable if that's necessary.
Right.
Okay. I see Mr. Diener has his hand raised.
Yeah, I'm sorry. I have this. So this is the chart that we're talking about here, and I made a check mark next to this 4 hours.
This is from your what was submitted last night.
It wasn't Exhibit 11. I don't know why that was used.
Exhibit.
No, the county calls it Exhibit 11.
It's Exhibit K1, right?
Yeah.
And this is from the this wastewater professionals on-site estimate. And so just like we were talking about with traffic, that the 8 hours is a window where people may come and go. The event is likely only going to be closer to 4 hours. And so when I did this calculation, that's the 4 hour calculation. Yes, we have the window of opportunity between 9 a.m. and 10 p.m. That's where the staff is using this 8 hour calculation.
Mhm.
So that anyway, I just wanted to clarify that. And again, the likely event peak and usage of water is more like the 4 hour versus at 5 gallons per person rather than the 15. So anyway,
Yeah. If it's limited to the events are limited to maximum 4 hours or something, whatever that would address that issue easily. But I'm not saying the applicant has to do that, but I understand staff's argument. I understand the applicant's argument. I'll consider those and
Thank
anything
you.
further that's provided. Mr. Smith, anything else you want to add?
No, what was the exact schedule on record?
Yeah, if you don't have anything to add, I'll go ahead and close the hearing. I will hold the record open for a total of 3 weeks. I'll hold it open until Thursday, the 16th of April at 4 p.m. for anybody to submit additional written testimony and evidence. I'll hold it open until the 23rd of April, Thursday at 4 p.m. for anybody to respond to whatever was submitted during that first period, the first open record week. No new issues can be raised during that second open record. It's only for responses to issues raised during that first week. And then until April 30th for the applicant's final written argument without any new evidence. If the applicant wants to submit that sooner, I will close the record upon receipt of that final argument. But regardless, I'll close it at 4 p.m. on the 30th of April. Anything anybody wants to submit has to be physically received by the county by 4 p.m. on the relevant date that I just mentioned. I will try and get my decision out by the 14th of May. I will send my decision to the county. The county will send it to parties of record. So anybody who has or does testify orally or in writing will be sure and receive a copy of my decision when it's issued. You can also just contact Ms. Fields to be put on the mailing list. And that concludes our hearing. Thank you.
Thank you for your time.
You-
Good day.
Thank you. Have a good afternoon.